This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky.
RICO isn't just for gangsters anymore.
The question is whether or not these are actually false rumors.
You always fight about it, but you have to turn it over.
Again, it's very inflammatory.
Yeah, it does feel like more colorful language than I'm used to seeing in a Missouri lawsuit.
I do not believe the Supreme Court of the United States would weigh in on this.
You get these superpowers as a lawyer of how to argue and how to kind of back people into corners. And
you guys are good at backing people into corners. It doesn't seem fair. Welcome back. I'm Sarah Fensky, and of course, I'm in for today's Legal Roundtable. We have a lot on the agenda today. A Wendy's franchise is on the hook for a legal settlement after a teen employee was sexually assaulted by a manager, someone who'd previously been convicted of rape. And a prominent lawyer wants St. Louis Circuit Attorney Gabe Gore to be sanctioned for allegedly withholding damning material about a police officer. And a chess grandmaster is suing the U.S. Chess Federation for how they handled her allegations of sexual assault. So let's get right at it. We are joined today by Mark Smith. He's a former associate vice chancellor and dean at Washington University. He taught law courses there for 30 years, and he's currently teaching social studies at Naranks Hall High School and also teaching some law internationally. Mark, welcome back.
Thanks. Great to be back.
And we're also joined today by Erin Luker. She's an attorney at Sadeh Harper Westhoff. She was previously a public defender for St. Louis County and a prosecuting attorney for the state of Missouri. Erin, welcome back.
Thanks for having me.
And last but never least, today we're joined by Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. He also does mediation services. Eric, welcome.
Thank you.
So a lawsuit filed in New Jersey makes serious accusations about the U.S. Chess Federation and how it handled the fallout around a St. Louis-based chess coach. Alejandro Ramirez was a coach at St. Louis University and the St. Louis Chess Club. Jennifer Shahade, a two-time national women's chess champion, publicly accused Ramirez of assaulting her in the past, and she claimed he was still engaging in sexual misconduct more recently. Her lawsuit claims the U.S. Chess Federation retaliated against her. This lawsuit, there's a very long lawsuit, 64 pages, has photos in it. That's somewhat unusual. It also starts with a trigger warning. Eric Banks, have you ever seen that in a lawsuit?
No, but that's why you're required to have different law licenses in each state that you practice in. I've never seen anything like that before.
This might be more of a New Jersey thing.
Or New York.
Or a New York thing. Okay. So this woman, Jennifer Shahade, in addition to apparently being a great chess player, she had been the director of women's programs for the U.S. Chess Federation before being, quote, constructively discharged. Erin Luker, that sounds like legal terms that maybe those of us in the public don't even know what that means. What is that?
Constructive discharge is when an employee resigns and the courts or the jury find that that resignation's not voluntary because the employer created a hostile work environment. So it essentially forces that employee to resign or to quit.
And so she's saying she came out publicly, posted on social media about what she says Alejandro Ramirez did to her. And this basically led to them pushing her to a point where she no longer had a job there. Do you think she makes a strong case?
Certainly, within all 68 pages of her petition, there are lots of claims being made for both her harassment claims, her claims regarding retaliation, her claims regarding defamation. And all of these will be looked at in the view of all the circumstances surrounding her case to see whether or not she meets those standards for constructive discharge.
What do you think is her strongest claim?
Certainly, there's been a lot of publications made by the Chess Federation that is directly rebutting allegations that she makes. And these are all played out in the public sphere. And here, at least in Missouri, discrimination or retaliation can come in the form of false rumors. It can come in the form of reprimands or negative performance evaluations, increased scrutiny. Mm-hmm. And it certainly seems like there's been at least some of those participations in her case. The question is whether or not these are actually false rumors.
Yeah. So they've put some material out there. I'm sure they would say they're just trying to get their side out there. She started this on social media. Mark, What do you make of that?
And also, the guy who published the article, and it's hard to read this because it's so long. And we were saying before the show started, I said, I haven't practiced in a while. I look at pleadings. I've never seen one with pictures before.
I've never seen that either.
Yeah, I thought maybe that was a new thing, but apparently it's not.
No, it's just a unique thing.
Yeah, a unique thing for this. I guess one of the lawyers is kind of a celebrity lawyer. But she also, in the constructive discharge, as I read it, she was kind of saying, too, that she couldn't be part of this organization because they were still sanctioning this harassment and mistreatment of young women. And that I think that adds to her claim. To your question about, I think this guy who wrote the articles is connected to U.S. Chess, but they're different organizations. And there was a suggestion that they kept bringing him and inviting him to organizations. The pleading talks about a lot about New Jersey connections because they're doing it there. I also found it interesting, and I'd be interested in what our other panelists think. There's a RICO claim. And RICO is something that's typically used for like gangsters.
Right.
That's what it was intended for. And so she has a RICO claim with, she specifically names U.S. Chess, this author, what was his name? Tamburo, and then Randy Bauer, who is the board president. But there's a bunch of unnamed people who are part of this
alleged
RICO
conspiracy.
Right.
Yeah. Is anyone buying this alleged conspiracy? Are these just disparate people acting alone, or do we actually have an organized criminal type organization here?
I'm not buying it.
No.
No, I think that they're throwing in the 68-page complaint, they have thrown in everything, including the kitchen sink, and that RICO claim will probably be dismissed with a motion to dismiss.
Erin, maybe you see a little bit more there than Eric does?
I do. It's a little nuanced in the sense that she's bringing in the fact that this federation works with children frequently. In fact, they're promoting chess. That's one of their primary goals within the organizations, to promote the play of chess among the youth. And so by advertising and exposing children to potential sexual abusers and potentially individuals who would harass them, that they're profiting as a result of that exposure. It is a unique way of pleading this concern, but how else would you bring that to the court's attention? How else would you try to rectify a wrong as you perceive it? Sometimes you can't fit everything into a nice, neat little package. Unfortunately, our laws aren't always going to allow that. And so I do think it's a unique way of pleading it. I think that's going to allow them to discover whether there is a conspiracy. In order to plead it and make that discovery relevant, you're going to have to show that it's tied to your pleadings and your claims. And there could be a conspiracy. I don't think we live in a day and age where we believe people don't communicate and don't plan and things aren't documented in that way.
Yeah, I agree with actually both. On the one hand, they're going to do discovery, and they may or may not find this conspiracy. I don't know. But this is different, I think, than the typical employment discrimination suit where, you sue the employer, you sue the supervisor. Everyone's kind of in the same umbrella. They're within the organization. Here, we have outside journalists, and I'm using air quotes on that, and other individuals who kind of are somewhat related. So I think it's a really kind of novel to plead this RICO. And RICO isn't just for gangsters anymore.
Sure.
The law has, the law is a dynamic thing, and creative lawyers figure out creative ways to use it. So.
Yeah, this certainly is a creative lawyer. I'll give them that between the photos and some of these novel theories of the law. Something else here caught my eye. Eric, I know you do a lot of work as a mediator. So when she filed this lawsuit, one of her allegations is that she was forced into a, quote, sham mediation here in Missouri. She alleges that the Chess Federation, quote, attempted to rush her into a sham mediation by having its then interim executive director, a former lawyer for a Fortune 500 company, send Shahadi to mediation mediation without an attorney, with a jurist it handpicked and set up dates to have such a sham mediation in its own backyard, Missouri, in order to silence her. And upon information, it was also hoodwinking the proposed jurist by failing to reveal the full story. This quote goes on, when Shahade finally obtained legal counsel, defendants failed to honor its offer to mediate because it never had any intention of having a real mediation. I'm wondering, this idea of trying to sort of push her into this mediation meeting when she didn't yet have a lawyer, is that something that's acceptable to do? Can that mediation take place without both sides being represented?
Perhaps, but it shouldn't go that way. It's unfair, in my opinion. You should have the right to have counsel at a mediation.
So they should have explained to her, okay, we want to set this up. We'd like to have mediation. You could invite a lawyer if you wanted. That would have headed off this charge of the sham mediation.
Yes.
Erin, would you agree with that?
Certainly that is ideal circumstances. However, mediations occur all the time in employment discrimination cases. So the EEOC has a mediation program where individuals, whether or not they are represented by counsel, can engage in mediation with their former employer. A mediator is supposed to act as that neutral. They're not really going to find a right or wrong. What they're going to try to do is bring both parties to the middle to find a resolution everyone can live with. And so that can happen with or without legal counsel. Is it ideal? Is it going to benefit the person who doesn't have a lawyer? Probably not. But there are very good programs in place that do encourage mediation and could encourage it with or without counsel.
And just for your audience, you hear these terms, arbitration and mediation, used a lot, particularly in employment situations. And arbitration is where you've agreed to let somebody decide the case. But a mediator, as the panelists have been saying, they don't get to decide the case. They're just trying to help you find something that you can both agree on, and you would have to sign then an agreement.
So this isn't like binding the
It's
way
not binding,
in arbitration you could be stuck with this decision. You're there without a lawyer. You have no idea what's going on. You're now subject to it. That's not how this goes.
No, you're exactly right. Arbitration is binding. Mediation is only binding if you agree to an outcome at the end. You can agree to mediate and say, well, we can't agree, and so we're going to agree to disagree, and then we'll go on and do whatever we're going to do. Maybe it's bring legal action, maybe it's just walk away. But I do think, there is a real unfairness when one side has a lawyer or is a lawyer and, somebody's not. You get these superpowers as a lawyer of how to argue and how to kind of back people into corners. And
you guys are good at backing people into corners. It doesn't seem fair, Erin.
Well, just to piggyback a little bit off the idea of this very inflammatory language used in the petition. And so going back to Missouri, in Missouri we're supposed to plead, our pleadings are supposed to contain short, fact-based statements in order to support our claim. And so that's why we don't incorporate the profile picture of our plaintiffs. That's why we don't include snapshots necessarily from pictures. We also have very heavy redaction requirements now here in Missouri. And so I think there's a lot of aspects of this pleading that are just outside of our realm here in Missouri, but also, again, it's very inflammatory.
Yeah, it does feel like more colorful language than I'm used to seeing in a Missouri lawsuit.
And a classic example is page 4, paragraph 6, second sentence, which begins, Shahade has been retaliated against with continued campaigns, including one inseminated from New Jersey. And I Googled inseminated every possible way, and it can only mean one thing. And I don't think that this is a typographical error.
I'm not sure that's inflammatory. I think that's just poor writing.
Okay,
I'd be interested. Did you guys notice they were talking about the no mechanism for whistleblower, and they kept looking at their federal filing. But I would think that they would have some kind of, everyone has a reporting for harassment because the Supreme Court gave employers this shield. If you have a reporting policy and it's not reported, you're kind of shielded. So do you think they really don't have a reporting policy? at an organization like this? Is that pretty common?
Certainly, I don't think that is going to be an acceptable defense.
No, it's not a defense.
It's certainly
Sure.
that, there was just literally no one who she could possibly discuss this with. Now, one element is whether or not the company she was working for knew or should have known of the harassing behavior or discriminatory behavior. Regarding whistleblowing, here in Missouri at least, it provides a very protective veil for our plaintiffs and our employees against any type of disciplinary action whatsoever is actually in our statute. And so here in Missouri, this idea that they are taking negative actions against her, but it has nothing to do with her reporting, they're going to have to meet that heavy burden to show that that's not just pretext for retaliatory action.
Because whistleblowers really do get protected in Missouri.
They do.
The law is on their side. Well, that's one thing we're doing right in Missouri. We are talking today to our legal roundtable. That is attorneys Mark Smith, Aaron Luker, and Eric Banks. I want to talk about another case in the news this month. This involves another hostile work environment. The Post-Dispatch reports that Wendy's and a store manager will pay $5 million to a teen victim of sexual assault. The teen, now 22, alleges she was subject to spankings, inappropriate touching, and graphic sexual remarks from her manager. This happened at the Bridgeton franchise. Now, the teen says she appealed to upper management. They apparently transferred this guy to another store, but he still continued to visit. Aaron, you deal with a lot of labor employment cases. Does it help that they tried, or does it hurt that it was apparently completely ineffective?
Both. So I would at least say we always want to see employers trying to remedy these situations because you have to work. People are going to work. In an ideal situation, I wouldn't have a job because everybody would follow the laws and we wouldn't have discrimination in hostile work environments. However, when we have companies saying that they are implementing new training or placing distance between these individuals, we actually have to see those actions fall through. You can't put a Band-Aid on a situation like this and just say, well, we tried and he just kept harassing. You have to make steps so that your environment is no longer hostile and it has to persist beyond just the initial approach.
Something else I found myself wondering about in this case, this manager had previous convictions for rape and sexual abuse. This is obviously somebody who should not have been around teenage employees, but these don't show up on CaseNet. One of the sad things you'll learn about court files is, there's unique jurisdictions. It's very hard to search across states. Mark, do you think they were responsible for finding this out when it would have gone beyond a simple Missouri search?
Yeah, so one wonders if, what kind of questions they're asking on their applications. And I think you're suggesting maybe this is a negligent hiring type of situation.
You sure wonder.
Yeah, where you have a fast food restaurant where you're going to have lots of teenagers working, and it might you might want to protect against this kind of thing. So I don't know what kind of questions they're asking. I would think those would be good questions to ask. Somebody maybe lies, but if you find out they lied, Aaron was talking about this, dealing with these harassers, and one of the ways sometimes you deal with the harassers is you fire them because you're saying you're not getting with the program and this is not acceptable, and so we're going to have to fire you, and you can't. That if they've lied about something, that gives you an easy way to
but they didn't disclose
Yeah.
this past conviction.
Yeah.
It does feel like you can't go around spanking your employees.
This
seems
is a
pretty
horrible.
clear cut.
Both of these cases, all of these cases, the fact patterns are they're really distasteful and horrible. And you feel, some teenage girl who's trying to work her way through high school, save some money for college, has to put up with this. That's just. We should have moved on from that. And so I think that's part of the reason you have these people settling out of court. We don't know All we have is the plaintiff's press release.
That brings me to a point I sort of want to mention here, because I saw this headline, this girl is going to get $5 million. And I thought, wow, good for her. Boy, $5 million, that's a lot of money. Well, that headline masks a far more complicated situation. She had an undisclosed settlement with the owner of this Wendy's franchise, but that $5 million figure comes from a default judgment against the manager, Leon Durham. Eric, what leads to a default judgment?
Somebody not thinking enough of the procedure to show up. So if you show up, by definition, you're not going to have a default judgment.
So this manager, he just didn't respond to
That is
this
correct.
Civil litigation. The judge says, hey, this is very bad what this guy did. He's not here to defend himself, but he chose not to be here and defend himself. I'm just going to slap him with a $5 million judgment. What are the odds that this young girl is ever going to get this $5 million?
Slim and none.
Yeah.
Now, Missouri does have a tort victim compensation fund, and so this fund is available to tort victims who do have these default judgments where the person who the default judgment is against is essentially judgment proof. What that means is that they don't have any assets, they don't have any finances, insurance, anything where they'd be able to produce some of the $5 million. And in those cases, the plaintiff, the victim, can apply through the state of Missouri to the Tort Victims Compensation Fund. Now, it's capped. The highest amount they can recover is up to, I believe, $300,000.
So there's a big difference between $5 million and $300,000.
And it's quite the process. It's a very difficult process. You don't necessarily need an attorney to do it, but I would recommend it because it is so complex. And it takes a while. It takes they only give these judgments out once a year. And so it can, if you miss that year, you're going to have to wait till the next year as well. So hopefully she sees some of that money if he is judgment proof, but it's not going to be anywhere near the $5 million.
So the fact, though, that the judge awarded her $5 million, does that help her get the max from the state fund that, I'm coming in with a $5 million judgment, I should get $300,000 rather than ending up with a lesser piece of that pie?
The state fund will calculate what your damages are, and that would include records, medical records, those sorts of damages, but as well as what the judgment was. And so there is a calculation that takes that into effect. I don't know what the impact of that is, but certainly I would think it helps.
Yeah, I was just going to say two takeaways for the people listening. One, as Eric said, a default judgment is a real judgment. I mean, so if you get served with papers, you can't throw them in the back of the car and just ignore them and not think about it, because you get that default judgment, which they're going to do, and they can go after you. The second thing is what Aaron was saying about being judgment proof, which I always said to my kids, when you're driving around, the people you got to really be careful about are the person in the '73 Monte Carlo it's all rusted out, and they're driving down South Grand Boulevard and they don't have any money, and if they hit you, they don't have insurance. We're not going to. So avoid those people. And then the super rich people, because they can get really good lawyers and just beat you down. It's us in the middle that have a little bit of money. We're the ones that are subject to the legal system, kind of. And so
a person who owned a house would probably hire a lawyer to respond to this because,
right.
They don't want the courts to take that. Yeah.
But if I got nothing, I figure, well, what are they going to do? I've got nothing anyway.
Yeah.
So,
why spend money on lawyers?
This guy's working at Wendy's.
Yeah.
So he probably doesn't have a lot of money.
Yeah. So, Aaron, thinking about this settlement that she makes with the Wendy's that allowed this to go on, these managers who maybe didn't deal with this situation properly, do you think the settlement with the franchise owner is anywhere near $5 million?
I don't know. I would say that settling out of court, there's a lot to take into consideration from both parties. What defendants and defense attorneys often do is make a calculation based off of the risk of going to trial, the risk of punitive damages, the risk of the cost of going to trial, the cost for having an attorney go through trial for you. On the other side, you have a plaintiff, and the calculations are a little bit different. The calculations are mostly based off of their own damages, and there's a huge emotional component to this. And so what we get in employment discrimination cases a lot is garden variety emotional distress. And so what that calculates and takes into consideration is that feeling in the pit of your stomach as you're driving to work because you just can't fathom another day there.
Sure.
It's those intangible items that are hard to put a dollar figure on. For this young lady who was a minor, who was this may have been her first real job, if you will, to be subjected to this time and time again, to try very hard to work through the system through her own managers and through her own supervisors, and to still be faced with such a hostile work environment, that intangible feeling may have been very difficult to put a dollar price on, and I guarantee you it was felt more than $5 million.
We're talking today to our legal roundtable. That is Erin Luker. We're also joined by Eric Banks and Mark Smith. Coming up, a request for sanctions against the prosecutors in that high-profile Bar PM case. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fenske. I'm now at St. Louis Magazine, but I'm here every month for our legal roundtable. Excited to be here today with Eric Banks, a former state prosecutor and city councilor. He's now at Banks Law. We're also joined by Erin Luker, an attorney at Sadeh Harper Westhoff. She specializes in labor and employment issues. And we're also joined by Mark Smith, who was recently teaching a bit about the law in China. He's a former dean at Washington University. He currently teaches social studies at Narings Hall High School. Now, we've got a big update in a high-profile case that we've talked about already on the show a few times. This involves a sometime panelist, Javad Kazali. You'll remember that police crashed an SUV into the gay bar in South City called Bar PM. And then the officer who responded to the scene arrested the bar's co-owner. Well, now Javad and his partners are going after the St. Louis Circuit Attorney's Office. The bar's co-owner still faces criminal charges for resisting arrest and misdemeanor assault. And Javad and his partners say prosecutors not only failed to turn over key evidence, but they didn't even try to get it from police. So at issue is what's called a Brady disclosure. Erin, you want to explain this one?
Sure. A Brady disclosure is based off of the Supreme Court case Brady versus Maryland, in which they found that there was a violation of the defendant's due process rights when a prosecutor withheld evidence that is favorable to the defendant or to the accused. Now, this evidence has to be material, so it has to be exculpatory, or it has to be material that would reference could influence the guilt or punishment phase for a defendant. So that's a Brady violation, is if failing to hand over that information.
So somebody like the co-owner of this bar, this is this man, Chad Morris, his lawyers are saying, okay, the lawyer who came in and handcuffed him within just, 22 seconds of showing up on this scene, this guy had a history of behaving in a hot-headed way. There's complaints that he roughed up other people. Eric, is that something that's potentially exculpatory, that's potentially a Brady issue that you've got to turn that over?
Yes, it is.
It's that clear cut?
Yes, it is.
Okay. Erin, I see you nodding. Eric's not oversimplifying this here.
It is not. So exculpatory evidence could also include evidence that can be used to impeach a witness. So impeachment deals more specifically with witnesses' bias as to how they're testifying, why they're testifying, as well as, whether or not they're going to lie, whether or not they are lying, or whether or not we have reason to believe they're not going to be truthful right now. And so even though it doesn't have to do with the case at hand involving the car accident at the bar, other instances of untruthfulness, other instances of misconduct certainly will go towards impeachment and may go towards his guilt as well.
Mark, this may make some people think about Kim Gardner and her famous list of officers, the exclusion list, I think she called it. That is dealing with some similar material there.
Yeah, I think it probably is. I mean, here, the thing I found interesting about this case, and this is not my area of expertise, so I'm deferring to both of our other panelists who know more about criminal stuff.
Yes.
But it seems like when I read this and looked at the pleadings, and we still haven't gotten a response from the prosecutor, I think, I think what they're saying is, yeah, we're going to try and get it, but we may need a court order or something. I mean, because my understanding, they're asking for personnel records. The circuit attorney in the city of St. Louis does not have those files. They would be in a separate agency, the St. Louis City Police Department. They're a county office. They're a different. I don't know what the setup of now. Are they part of the city?
They are part of the city now.
Yeah.
But they are separate agencies, and let's face it, the police do not make it easy for anyone to get their hands on these personnel records.
So I could see the police, the POA coming in saying some kind of to shield the personnel records, saying that they're private. Now that doesn't mean they're going to be protected, but it may mean that we just can't get them immediately.
And I should say the POA, that's the police union, which is going to fight tooth and nail to try to protect these officers. And Aaron, yes, I was somewhat surprised as I read the filing in this case where they had not made a super formal request for these records. There had been texts going back and forth where Javad's partner was saying, hey, we need to get our hands on this stuff about this officer. We know you have some stuff in your possession. The cops have some stuff in their possession. Turn it over. Is it that simple that they can just text and say, yeah, I want this stuff?
So Missouri Supreme Court Rule 2503 actually places the burden on the prosecuting attorney's office to disclose Brady material. And so this should be disclosed whether or not there's a specific request by defense for Brady material. And going to the agents of the state, so there is an obligation both based off of Brady, off of Giglio v. U.S., for the prosecuting attorney to also access records that pertain to Brady material that are within possession of the agents of the state. And Missouri has pretty routinely ruled that police officers are agents of the state. And so this is irrespective of whether or not it's in good faith or bad faith. So whether or not a prosecuting attorney's office says we didn't know about it or we didn't seek it out, they will still be held accountable whether or not they produce this information. And ultimately, if police officers, if the union, whomever it is, prevents them from obtaining this evidence, the court can issue sanctions against the prosecuting attorney, and those sanctions could include, that could include dismissing cases. It could include suppressing evidence. It could include anything that's available to the courts. Now, courts are really reluctant to suppress evidence as a result of these materials, but what other options are there if the purpose of Brady is to ensure justice and ensure that the system is protecting the innocent?
Yeah, I mean, this is something where it sounds like there's a possibility there could be sanctions if this stuff isn't turned over. Do you think this is a premature request for sanctions this early on in the case, Eric?
No, I don't. No, I think it's appropriate.
Okay, so these guys are asking for something they should be given. And the judge should take this seriously. You know, there's another case that was in the news this past month that I think touches on some of these same issues. This is an assistant city councilor who faces a big fine for withholding a damning audit from defense attorneys. It turns out these are the same defense attorneys. Javad Khazali, he's involved in this one too. The U.S. magistrate ordered the city councilor's office to turn over the documents relevant to the lawsuit filed by the family of Mansour Balbay, who was shot by St. Louis police. The assistant city councilor on that case apparently didn't do that. He even held the documents back from others in his office. The magistrate said she'd issue sanctions. She has just ordered an $18,400 fine. Eric, during your time as city councilor, did you ever see one that high?
No, I didn't, but I haven't seen too many fact patterns as egregious as what this attorney's been accused of either.
Yeah. I mean, he supposedly just held this back, wouldn't share it with anybody. Aaron, this is exactly the kind of thing you're talking about. You can't do that.
Well, in this circumstance, this is a civil case. So Brady applies to criminal cases, and that obligation for Brady material applies specifically to criminal cases. However, the protection or the umbrella that the city councilor was referring to, I think, is it was protections under sunshine request. So this material was coming through or being requested as a result of sunshine, as well as normal disclosure processes. And there are protections for personnel information, some limited protections for personnel information under sunshine. However, the court, there's there's a mechanism in place for the court to review those documents in camera, and that's what the court did in this case. And the court found that sunshine protections did not limit the disclosure of these materials. And I believe it was boxes and boxes of material. We're not talking about one email. We're talking several banker boxes of material. And the court said, this is not protected, hand it over, and they refused.
Yeah, my sense was that Tony Messenger was doing the sunshine request, but wasn't this just under normal discovery requests where, and you have a duty, so, before something goes to trial, the court wants you to, it's not like Perry Mason where you have surprises at trial. Everyone's supposed to know what's going on, and you make requests for documents, and you always fight about it, but you have to turn it over, and this guy didn't. And it's interesting. You might say, well, why did this lawyer get hit with the? And the judge said, well, the city's not a party, so I can't give it to the city. They'd already been dismissed, and these other lawyers, they weren't involved. They didn't do anything. So one wonders, will the city of St. Louis now kind of indemnify this guy?
They'll just write the check?
Yeah, because $18,000, that's a lot of money.
Sure is.
And he's, I think, now working in the county counselor's office, so he's not making, huge amounts.
And malpractice insurance does not cover sanctions or fines that are intended to punish individuals.
Oh, that's interesting.
Oh, boy.
So if the city's not going to pay for it, certainly it'll be coming out of pocket.
Well, it's an interesting case. I think we'll have to keep an eye on this Bar PM thing. It's worth noting that the circuit attorney's response to this is, hey, we're going to have a legal filing here. You'll see our side of this. We have not yet seen that.
And just going back to whether this should be dismissed, I always thought, because we talked about this on another show I was on, it's kind of a goofball. I mean, to bring this prosecution, particularly when you have this history of, gay individuals being, you go back to Stonewall and before, of police harassing gay people. I'm not saying police do that all the time, but there's
they did.
But there's this history,
tense,
right?
They did.
And you can't kind of to then say, okay, now we're going to prosecute. It just seems so tone deaf and just so inappropriate. So,
it is interesting they haven't yet dropped the misdemeanor case.
I don't get that.
Yeah.
Right.
So we've talked many times on this show about Marcellus Williams. He's a death row inmate convicted of murder. He's always insisted he didn't do it. St. Louis County Prosecutor Wesley Bell filed a motion to vacate his conviction. He says there's compelling evidence that we should be looking at other suspects. But the state attorney general wants to block a hearing to examine whether the conviction was wrongful. Now there's a date for an execution at the same time as we've got this separate lawsuit filed by Wesley Bell's office. This is all very complicated. But Erin, this is a matter of life and death. What are you watching on this one as it plays out?
So this one is really interesting because a new law went into effect in August of 2021, 547031, that allows any prosecuting attorney to move or vacate or set aside a conviction at any time if they have information that the convicted person may be innocent or may have been erroneously convicted. And so the interplay here that's most interesting from a legal standpoint is the Attorney General's office has filed their writ with the Supreme Court because Rule 3030 says that no other court other than the Supreme Court can vacate an execution date without the Supreme Court, only the Supreme Court can vacate that date. And so what's interesting is this pleading by Wesley Bell would essentially vacate the execution date because if it's found to be credible and his conviction is overturned or his sentence is overturned, then he wouldn't be executed. But it's not specifically vacating that execution. And so this is an area for, I think, the legal nerds who haven't explored this before. And I think that this is a case of first impression. So obviously we don't have very many executions going up before the Supreme Court at this date and time, certainly not since August of 2021. And so this will be the first time the court weighs in on the interplay between these two laws.
Yeah, and I don't know. I mean, Bell filed this motion in January saying that he thought this was a wrongful conviction. The Missouri Supreme Court didn't issue a warrant for the execution until June. It seems like this wrongful conviction case was already in motion. Mark, is that something the court's going to take into account as they're trying to synthesize these two different matters?
I don't completely get this one. And when I looked at the Supreme Court decision, from July 12th. In a footnote, they say they're aware of the prosecutor's motion, but they say we've already rejected his direct appeal, his 2915 motion, and his writ of habeas corpus, and then says, moreover, there is no allegation additional DNA testing has been conducted since the master oversaw DNA testing, and this court denied Williams' habeas petitions. But when I look at the stuff from the Innocence Project and stuff, it doesn't seem that way. So one hopes that the Missouri Supreme Court will do the right thing. Leslie Bell will continue going forward, I don't know what you guys think.
Aaron.
Well, the motion before the circuit court in St. Louis County has a different standard than what the standard the Supreme Court was applying in the initial appeals. So the standard under this new law that took place in 2021 is that the court can find by clear and convincing evidence of actual innocence or a constitutional error. And so even though the Supreme Court has explored at least some of these issues before in other appellate cases for this particular defendant, the issue and the question before the circuit court in St. Louis County is different and is unique, and there is new information. And so even if the Supreme Court reached a different conclusion than the circuit court does in St. Louis County, it would still be valid under this law.
So this is one, matter of life and death. You don't get to undo an execution. It's going to be very interesting to see how this plays out. Do you think this is going to the U.S. Supreme Court?
I think it will. I think there will be petitions to the Supreme Court. I do not believe the Supreme Court of the United States would weigh in on this, though. They've taken many opportunities, I think, to deny writs involving this case. And because it's an interplay between two rules and two statutes in Missouri, I don't think the Supreme Court will weigh in.
So sounds like Missouri Supreme Court will get the last call on this, and we'll see if that execution date goes forward in September. I want to thank our legal roundtable for joining us today. Just so many interesting cases, so many interesting facets of the law to talk about. Aaron Luker of Sadeh Harper Westhoff, thank you so much for joining us.
Thank you.
And Eric Banks of Banks Law LLC, thank you for joining us.
Thank you.
And Mark Smith, longtime a teacher of the law, also at Narings Hall High School, thank you for joining us.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.